Good day, ma'am. Good day, classmates. Today, I'm going to report about Module 7, Social, Ethical, and Legal Responsibilities and the Use of Technology Tools and Resources. My topic is all about Lesson 3, Intellectual Property Rights on the Development and Use of Digital Materials. Hello, everyone. I'm Margie P. Banyes, and I am the reporter of this topic. Let's talk about the introduction. According to World Intellectual Property Organization, intellectual property refers to creation of minds such as inventions, literary and artistic works, designs and symbols, names and image used in commerce. An intellectual property rights is a right held by a person or by a company to have exclusive rights over this. Internationally, these intellectual property are protected by the World Intellectual Property Organization, to which the Philippines is one of the 191 members of states. In our country, we have the Intellectual Property Office of the Philippines, which administers and implement state policies in relation to intellectual property. This office was created through Republic Act 8293. This act defines intellectual property to include copyright and related rights, trademarks and services marks, geographic indications, industrial design, patents, layout design or topographies of integrated circuits, and protection of the undisclosed information. In the education setting, copyright and related rights are the ones applicable. Now let's talk about copyright. Copyright refers to the legal right given to the owner of original work or intellectual property. These works are original intellectual creations in the literary and artistic domains protected from the moment of their creation, which include the following. First, books, pamphlets, articles, and other writings. Second, periodicals and newspaper. Third, lectures, sermons, addresses, dissertations prepared for oral delivery, whether or not reduced in writing or other materials form. 4. Letters. 5. Dramatic or dramatico-musical compositions, choreography works or entertainment and dump shows. 6. Musical composition with or without words. 7. Works of drawings, painting, architecture, sculpture, engraving, lithography, or other works of art, models or designs for works of arts. 8. Original ornament, design, or model for article of manufacture, whether or not registrable under industrial design, and other works of applied arts. 9. Illustrations, maps, plans, sketches, charts, and three-dimensional works relative to geography, topography, architecture, or science. 10. Drawings or plastic works of scientific or technical character. 11. Photographic works, including works produced by a process analogous or photography, lantern slides. 12. Audiovisual works and cinematographic works and works produced by process analogous to cinematography or any process of making audiovisual recordings. 13. Pictorial illustrations and advertisement. 14. Computer programs. And 15. Other literary, scholarly, scientific, and artistic works. So those works are protected by the intellectual property, which is the copyright is one of the legal rights given to the owner and of the original works. As we all know, the internet is a very rich source of these materials, and we should be careful in using them. because these works are protected by the sole fact of their creation, irrespective of their form or mode of creation, as well as their content, quality, and purpose. Copyright infringement is the use of works without permission where the copyright holder has the exclusive right to produce, distribute, display, or perform the protected work, or to make derivative works.
Also, proper citation should be used when including them in our output in order for us to avoid any violations.
Below are the guidelines on online use of copyrighted materials by Smaldino, Lothar, and Rosell 2012. First, contrary to popular opinion, all materials on the internet is copyrighted unless stated otherwise. It is copyrighted even if it does not display the copyright symbol. Second, an email is an original work fixed in a tangible medium of expression that is covered by copyright. Hence, it is recommended that you should not forward any email without permission in consideration of both Copyright and Privacy Act. Third, downloading an article from a newspaper website, making copies and distributing them to your students prior to a class discussion on the topic is permissible following the current postal copy guidelines, which permits making multiple copies for classroom use. The exemption would be individually by-line copyrighted articles or articles from a source specifically designed for educational market where such articles cannot be copied legally for class distribution. Adapted by Becker 2003. Fourth, you cannot post students' essay, poems, or other works on the school website unless you have permission of the students and their parents or guardians. Fifth, educators should treat copyrighted materials from the internet the same way they do to print formats. The best guideline is to always obtain permission. As we all know, these guidelines is an important thing to remember in getting information or any works, original works from the internet source or in a library or newspaper or any kinds of materials, because in order for us to avoid violating the law or accusing any kind of violations.
Now let's talk about copyright infringement versus plagiarism.
Another violation of intellectual property is plagiarism. Although plagiarism and copyright infringement are related ideas, these two are different. Plagiarism, according to plagiarism.org, it is an act of fraud. It involves both stealing someone else's work and lying about it afterward. Plagiarism.org further elaborates the following as plagiarism. First, turning in someone else's work as your own. Second, copying words or ideas for someone else without giving credit. Third, failing to put a quotation in a quotation marks. Fourth, giving incorrect information about the source of a quotation. Fifth, changing words but copying the sentence structure of such without giving credit. 6. Copying so many words or ideas from a source that it makes up the majority of your work, whether you give credit or not. See our section on fair use rules. 7. For image, videos, and music, the following are counted as plagiarism. First, copying media, especially image from other websites to paste them into your own papers or website. Second, making a video using footage from other videos or using copyrighted music as part of the soundtrack. Third, performing another person's copyrighted music or playing a cover. Fourth, composing a piece of music that borrows heavily from other composition. In other words, plagiarism refers to copying the work of other and claiming it as one's idea or without proper attribution, while
Copyright infringement
is copying one's work without obtaining permission. In this sense, copyright
infringement
is a violation of right of copyright holder, while plagiarism is a violation of right of the author. We have to note that not all authors are copyright holders. There are cases when the publisher owns the copyright. In addition, copyright
infringement
is a legal violation, while plagiarism is an ethical violation. That's all for today, guys. Thank you for listening. Once again, good day.